Hi, everybody. Thank you so much for coming. We're having a couple of technical difficulties. So if you could please just give us around 5 minutes to figure this out. We will be with you very, very shortly. I am so sorry. 5 minutes. We'll see you soon. Hi, everybody. Thank you so much for being here today. Yay, we figured out our technical errors. Hi, Missy.
Hi.
How are you? Thank you.
Good. How are you?
Good. Thank you for being patient, everybody. I see a ton of people have logged on. Thank you for your patience, waiting for us while we figure out this world of technology. All right, let's get started now that we are a couple minutes late. All right. Well, good evening, everybody. Welcome to Guardianship 101, brought to you by NAMI Cook County, North Suburban, and Mitzi Firmich. I am Bree Hoekstra, the program director at NAMI Cook County, North Suburban. NAMI, the National Alliance on Mental Illness, is the nation's largest grassroots mental health organization, providing public awareness, no-cost support, and education programs online and in person so that people and families affected by mental health conditions can build better lives. We are a lifeline to individuals and families who don't know what to expect in their difficult life journey. We offer classes and support groups and do a lot of local advocacy for mental health. Our programs are completely free of charge and open to those in our 17 community service areas, but we don't turn anybody down. Our topic tonight deals with the basics of guardianship. And according to the National Guardianship Association, guardianship is a legal process utilized when a person can no longer make or communicate safe or sound decisions about his or her person and or property, or has become susceptible to fraud or undue influences. NAMI National states that 1 in 20 US adults experience serious mental illness each year, and only 64.5% of adults with a serious mental illness received treatment in 2020. According to the Special Needs Alliance, when someone is living with severe mental illness, the process of obtaining guardianship can be particularly complex. But the article goes on to say that the goal, of course, is to interfere as little as possible with the person's independence, seeking to intervene only when there is an issue related to health, safety, or exploitation. So when is it appropriate to pursue guardianship? What are the various types of guardianship? Who can act as a guardian, and what are the responsibilities and limitations? Our speaker tonight will answer these questions and will also spend time examining what happens when a guardianship proceeding becomes contested. We will leave plenty of time for question and answers at the end. If you would like to type in the chat box during our conversation, please do so. Tonight's guest speaker, Mitzi Firmage, is an associate in the Estate and Trust Administration and Litigation and Estate Planning and Asset Protection Practice Groups at Schuhag and Teskin Attorneys at Law. Her focus includes routine guardianship matters and much more. Missy utilizes an intentional and an empathetic approach to her practice as she leads clients through often emotionally charged legal matters. Missy's guardianship practice is rooted in the notion that persons with disabilities have the right to live with the utmost dignity. She routinely represents corporate and individual fiduciaries throughout the phases of contestant and non-contestant guardianships for adults with disabilities and minors. Missy litigates sensitive matters involving competing guardianship petitions, financial exploitation, and asset recovery. Since 2020, Missy has been selected as a Super Lawyers Rising Star, an honor given to no more than 2.5% of all lawyers in Illinois. Community education is an essential component of Mitzi's life. She currently serves as a junior board member of Chicago Volunteer Legal Services, or CVLS, along with many, many other things. So we are so thrilled to have her here tonight, and I am honored to welcome our guest tonight, Mitzi Firmage.
Great, thanks, Bree. So as Bree said, I focus my practice on trust and estate matters, which include guardianships, both routine, contested, and other related estate matters that are routine and contested too, and decedents' estates, and trust litigation matters, and estate litigation matters, and things of that nature. So I focus the majority of my practice on litigation. So I definitely, I cross a lot of interesting territory. I deal with a lot of interesting things on a daily basis. But for purposes of today, we're just going to learn about the general nature of guardianship when it's appropriate. I'll give you kind of a little bit of background on what you can start thinking about, when a guardianship becomes contested and what approach you might want to take. Otherwise, there's definitely, I get questions all the time about individuals who specifically and only have mental health related concerns and whether guardianship is appropriate solely for that purpose. A lot of times parents want the ability to hospitalize a child or administer psychotropic medication. That's a separate discussion. I'll touch on it a little bit today and provide everybody with just some general statutory resources that they can use moving forward, but that presentation would be a different one in and of itself, because guardianship isn't a suitable mechanism to obtain control over an individual who is solely suffering from mental health issues. That doesn't mean that we don't have situations where there are dual diagnoses and things of that nature, where we might have an individual who has dementia, who also has bipolar disorder or something along those lines, in which case the laws and legalities of administering psychotropic medication do become different if that individual is residing in a nursing facility. But just kind of big picture, the purpose of guardianship and the way that it's designed and the law in Illinois is not, you have this concern, you want to administer this medication, you want to put this person in an inpatient facility. Those aren't things that guardianship allows, and I'll walk you through some of those statutes. So give me 1 second. I'm going to start the screen share, and hopefully this works. Perfect. Oops. Okay, great. So my primary practice is in Cook County. And so largely, I think that's a good place for us to start for this purpose. We're going to start with adult guardianship. If we have time to get into some considerations of minor guardianship, we can. I don't know that that's, again, I think that's a separate and distinct presentation from what we have today. But, if you don't know, the Illinois Probate Act is what controls the process of guardianship for adults with disabilities and for minors as well, both minors who have disabilities and the process of setting up a minor's estate by virtue of receiving an inheritance or things of that nature. So when is guardianship appropriate? Someone comes in and says to you, my family member has X, Y, and Z diagnosis. Like I said, if it's somebody coming to you and saying, my son is 19 years old, he has schizophrenia, I'm unable to get him to be compliant with his medication regimen, I'm unable to force a hospitalization, that's not a situation where guardianship would be an appropriate mechanism. It's not going to get the person where you need to go. The mental health code controls in situations like that, and the guardian specifically doesn't have the ability, even if appointed as guardian of the person, to commit somebody to a mental health hospital. That still has to be the recommendation of the hospital. For involuntary commitment purposes, still entitled to a hearing, all of that. So what we have when we have a guardianship issue is we have somebody who presents as incapable of making personal and financial decisions. Now, it's not always obvious. I had an individual recently who presented for all intents and purposes as somebody who really wasn't struggling with personal and financial decision making. His primary care physician felt differently. His family felt differently. If you were to converse with him, you probably wouldn't have thought that he was somebody who was substantially impaired. But upon examination of an in-depth neuropsych analysis and some brain scans, it became very obvious that he had had a series of mini strokes that ultimately impacted his ability to make reasonable decisions and appreciate the outcome of those decisions. You might have somebody who is at risk or already is the subject of financial exploitation, abuse, or neglect. You would see situations where somebody is taking care, advantage of somebody financially. Perhaps they had one estate plan in place. All of a sudden you become aware that they have a new estate plan in place. They might not even remember executing that estate plan, things like that. And again, mental health concerns, a lot of times we do deal with those on a dual diagnosis purpose, but it's typically not, the primary reason why you're seeking guardianship. So when you're ascertaining whether or not guardianship is actually needed, first and foremost, you'll want to ask the family, does this individual have powers of attorney? You can't have a guardianship and powers of attorney at the same time. It's one or the other. So times where the powers of attorney exist, but they're insufficient, are situations where perhaps the agent nominated under the power of attorney is taking advantage of that individual who we have alleged disability. They're always a person with alleged disability until they're actually adjudicated. And I like to make sure that we be, very consistent and intentional about our language, especially because, an adjudication event really is significant. You are taking away numerous rights of a person that they would have absent a guardianship. So, the person presents powers of attorney to you, but they might say the person who's appointed under these documents, I'm actually concerned about, they're taking money, they're taking advantage, they took the person to the bank, they presented the document, they withdrew a bunch of money. Those are definitely major alerts for you to think, okay, we need to go ahead and proceed with an emergency appointment of a guardian. At that point, the powers of attorney would be suspended or potentially revoked. And, we'll kind of weave this in throughout the process of the presentation, but of course, that person will receive notice of the petition for temporary guardianship. They'd have an opportunity to be present and appear, and they may contest it. They may say, well, I'm the agent nominated. The agent, the power of attorney controls, absent you being able to prove that I've done something different that's inappropriate for whatever reason. It also could be that the person never had powers of attorney documents in place. So think of, an individual who enters into the hospital is saying, we need a discharge plan, and we don't have one. We don't have anybody who's able to make decisions for this person. Depending on the level of decision-making that has to be put in place, the Healthcare Surrogacy Act really might not be enough. And it may be a situation where either the hospital petitions for guardianship or they call the closest family member and suggest that that process be started. So there's two distinct types of guardianship, guardianship of the person and guardianship of the estate. Guardian of the person is making any of those routine day-to-day decisions that person can't make on their own. Guardian of the estate, same thing you would think, making any of the financial decisions that the person's incapable of making. A temporary guardianship is what you'd obtain on an emergency basis. It's in place for 60 days, but can be extended up to a maximum of 120 days without the necessary filing of another petition. A lot of times if we have either family members that are objecting or the respondent, his or herself objecting to the guardianship, you might have several petitions for temporary guardianship, but the goal is that there's always a decision maker in place. And so the way it works in practice, if we go to court, we have an emergency guardian appointed, a temporary guardian. You delineate all the rights that the guardian has for that period of time in which they're going to be a temporary guardian. It expires on a date certain set by the court, and then that order controls. That order is what you provide to a nursing facility, a bank, hospital, anything in the interim while we're trying to figure out who's ultimately going to act as this person's permanent guardian. A limited guardianship applies more infrequently. We use them a lot for settlement purposes, but a true limited guardianship is designed to carve out certain rights to that respondent. And so I had a situation where I represented the respondent. So I represented the person who was the alleged disabled individual because they do have the right to counsel. And so if they ask for it, the court will appoint somebody, or sometimes people will call individually and say, look, my family member filed for guardianship. I'm not in agreement. I don't need a guardian. And here's all the reasons why. And they are entitled to have their own attorney for that process. A little bit different than what we saw with Britney Spears, where she really didn't have the right to counsel for the vast majority of her proceedings. And I think that was a big issue that made the news is, okay, why is it that they determined that she lacked the capacity specifically to have her own individual attorney? So important to my client in that proceeding was not necessarily that she was objecting to the guardianship, but she wanted to retain the ability to vote, and she wanted to retain the ability to have her own attorney, so that if she ever had any questions about where she was going, who her caretakers were, if her family members decided that she needed to go into a facility, that she had somebody independent that they could call. And after consultation with the family, that was most appropriate. So limited guardianships can look very different depending on the situation that you have. But again, they're often used in situations where a respondent is objecting to the guardianship itself as, sort of what we look at as a dignity saving measure. This is a situation where the respondent absolutely needs a guardian. The report of physician, which I'll get to in a little bit, details the person's explicit need for a guardian. The medical records support it. The family members are all on board, but the individual is saying, I really don't want this. Sometimes we can come up with a scenario where we're saying these are the certain things that you'll be able to maintain and preserve rights to. And sometimes we aren't. Sometimes a limited guardianship simply just isn't enough protection. Likewise, powers of attorney aren't always enough protection for, the very brief reasons that I went through. But when, if we have any estate planning attorneys on here or anybody who's involved in that space, a lot of when we're recommending the appointment of an individual under a power of attorney, we're telling that person, this is your most trusted, your most trusted person from a healthcare standpoint for a healthcare power of attorney, and from a financial perspective as your financial property power of attorney. And the person may appoint somebody that they really trust at the time, who ends up, turning around and not being the most trustworthy source. So when you're in this information gathering phase, it depends on who's calling you and what information you can gather, right? If it's the respondent that's calling you and seeking help, they might not be able to give you a ton of information on where their assets are located or what exactly is going on. They might just know that they need some help. Otherwise, the family typically will be able to give you some baseline information on here's what we're experiencing and here's what we're seeing externally that's causing concern. And the next step is moving forward and finding out what exactly would a physician's recommendation be in this situation. If the person has a primary care physician, that's typically who you would go to first. But if they don't, or if the primary care physician is unwilling to fill out what we call a report of physician, specifying the need for a guardian, there are private individual physicians that we utilize frequently to conduct evaluations that are, more detailed in nature. At this point, the statute, and it causes a lot of debate in our community, requires that the person filling out the report of physician be a DO or an MD. It can't be somebody who, it can't be an NP or a PA. It can't be a psychologist, which, some practitioners look at from, kind of negatively, because they say, well, wouldn't the psychologist be somebody who knows that person best and be able to opine on their capacity? But right now, the law is what it is. Those are the people who can actually opine on capacity. Expectation setting with the client early on about the guardianship is important. What guardianship can do and what it can't accomplish. And because we probably have a lot of individuals here who practice or are focused on in the mental health space, that's a really important upfront expectation setting goal. So disability under the Probate Act is defined as somebody who's 18 years or older who, because of mental deterioration or physical incapacity, is not able to fully manage his person or estate, is a person who with mental illness, or a person with developmental disability who, because of either of those, cannot manage his person or estate, or because of some other reason, excessive use of intoxicants or drugs, wastes his estate and exposes himself or his family to suffering. This last one doesn't, typically apply, but we do have situations, and a case that I'm working on right now that's highly contested, of an individual who does have an excessive illicit drug issue. And as you probably would anticipate, that now is paired with several other diagnoses that we've learned throughout the process of reviewing medical records and things of that nature that the person probably wouldn't necessarily present with if we didn't have that other medical information on hand. The standard for adjudication of a person is clear and convincing evidence. Again, the type of clear and convincing evidence in our cases typically consists of a report of physician. The level of detail that goes into it can really vary, but the content of the report itself is really important. It has to specify to the court whether the person is partially incapable of making personal and financial decisions, or totally incapable of making personal and financial decisions. That's not for the family to decide, that's for the physician to decide. And what we don't often see in the first report of physician is really clarification on, if somebody's only partially able to make those decisions, well, what decisions can they make? Because I come from the standpoint, and most of the practitioners in the space do, of we are trying to find the least restrictive mechanism when we're approaching guardianship. As we know, you're taking away a lot of civil liberties for the person that's involved in the adjudication process. And so, if we see something on a report of physician that indicates that the person has some ability to make decisions, the follow-up with the physician who wrote the report is essential to say, what decisions is that person capable of making? Can they manage a small allowance? Do they have the ability, to make certain health decisions for themselves, things of that nature. Clear and convincing evidence. Also, there's a guardian ad litem that's involved in the process of appointing a guardian for an adult with a disability. The guardian ad litem's role is an independent role. They get appointed by the court, and the purpose is to ascertain whether or not the person is objecting to guardianship, and also what the family's position is on guardianship. Not all families agree. My space, because I'm dealing exclusively with families and corporate fiduciaries in my role, it's emotional, and everybody comes at it from a different standpoint. And sometimes you have kids who, best of intentions, have a different view of what's best for their mom or their dad. One person thinks the facility is going to meet all of their needs, and the other person says, well, I'm living in the house and I'm able to take care of mom, and I'm able to be the guardian, and here are all the reasons why. And the other sibling saying either that's not the most suitable arrangement for her, she's at risk of fall, she's at risk of exploitation, you're exploiting her, whatever the scenario will be. The guardian ad litem is super helpful in that process, because they're able to come in, talk to the respondent and say, what do you really want here? Now they're going to be, relaying to the court what the respondent wants, even if it doesn't always necessarily make sense. The guardian ad litem's responsibility is to advocate, for the position put forward by the respondent, while also indicating to the court whether or not they believe that that position is in the respondent's best interest. So, for example, a typical situation where the respondent wants to stay at home, but that is no longer feasible, the guardian ad litem would bring to the court's attention that the respondent's goal is staying at home, but maybe for financial reasons or other related health reasons, they can't stay at home, and they would have, the guardian ad litem would express that while that's what they desire, it's not necessarily in their best interest. Absent from really what I'm talking about today and what people on here may come across frequently is what happens when somebody loses capacity, but they really don't have the savings or means to enter into a nursing facility. Medicaid planning is a whole separate part of this practice of law, and what's required for the spend down period and what that looks like. We're not going to get into today, but I'm certainly happy to provide resources or answer questions on that at a later date and time. But that's often one of the biggest sources of contention. We have a whole range of people who become disabled for whatever reason at whatever point in their life, and the range of resources really can impact what is the recommended approach for the guardian to take, and also what the guardian ad litem is willing to support as a result. So again, we have three sort of combinations. Someone might only need a guardian of the person, and that could be a situation where they have no estate. And so, if you think of a child who just turned 18 and attained the age of majority, maybe that child is diagnosed with autism and their only financial resource is Social Security disability. That's managed separate and apart. There's a representative payee who manages those assets. Those don't have to come into the estate. And for that purpose, you would just have a guardian of the person. If that person eventually comes into money, let's say they inherit money from their grandparents, and ideally, in the best case scenario, the grandparent has created within their trust a special needs trust that doesn't jeopardize that person's access to benefits. At that point, there would need to be a guardian of the estate appointed as well. Typically, what we see is both guardians are appointed, person and estate. In Cook County, if we have an individual who has assets over $500,000, the court will look to us to determine if a corporate fiduciary is a more appropriate arrangement. And so that's a bank that's serving in that role, or there are a few care agencies that are willing to serve in that role too. At that point, their management fee of what they take to manage those assets typically is less than the required amount that if it were an individual serving as guardian of the estate would have to give to a bond company. You have to be bonded to act in this role, very different than a power of attorney who doesn't have to be bonded. Although I will say that potentially if they did have to be bonded, we might see a lot less issues with powers of attorney than we do in my space, because they would be responsible for reimbursing, right, the person's estate for whatever they find a way to take. But in guardianship situations, there's a bond. That bond is paid out of, we're using the term ward now that person's adjudicated, paid out of the ward's estate. That gets paid on an annual basis. The family members aren't responsible for that. And that gets paid to the bond company. The purpose being that if somehow, some way, this person who is acting as guardian of the estate manages to take money out of that account and steal it, the bond company is required to make the estate whole, and then they would go after and sue that person individually for recovery. It ideally doesn't happen too often because you do have the oversight of a court, plus you have an attorney involved. You have to have an attorney involved in a guardianship, and so hopefully all those protections added together mean that the person's not going in and making grave errors in judgment when spending that money. Again, guardianship can only be utilized as necessary to promote the well-being of the person with a disability and to protect them from things like neglect, exploitation, or abuse. And again, we are all coming as practitioners from the standpoint of maximum self-reliance and independence. So to the extent that you can include the adult with a disability in decision-making processes, that's always my approach. And it's, again, only ordered to the extent necessary to actually achieve those outcomes of managing those situations. So by way of example, you might have an individual, there's multiple thresholds of capacity, and there's multiple thresholds of what you need to do certain things. So, bare bones, revoking a power of attorney for healthcare requires no capacity. You can do it even if you're, have a disability, which is why a lot of times if we think that's going to be the next step for somebody, you'll go ahead and pursue guardianship and suspend that power of attorney, and ultimately it'll be, permanently suspended while the guardianship is in place. I just lost my train of thought. I guess that's what happens at 7 p.m. Different thresholds of capacity. And so when, same thing goes for an individual who can make personal and financial decisions, those are different thresholds than somebody who can execute an estate plan. That's called testamentary capacity. It's a different approach. Same thing as medical decisions. You might have medical decisional capacity. That can be in conflict sometimes with the guardian of the person's responsibilities and duties. Let me just check my time here so I'm not over talking on too many things without, us getting to the point. But medical decisional capacity, it comes into play if you have an individual who, let's say they're receiving chemo treatments and they say, I don't want to do this anymore. And the physician advises that if they stop receiving chemo, that the outcome will be that they pass away. Whether or not they can appreciate that outcome is where the guardian does or does not step in. The court would be consulted as part of that process because, again, it's a pretty major one, end of life. But we wouldn't have a situation where we have a guardian appointed and it's just a blanket appointment where we're not considering anything ever again. Especially in a situation, if you're coming in, the person's been exploited, let's say the exploiter changed the estate plan or convinced them to change the estate plan and you need to undo it. We do now have in Illinois the ability to do court authorized estate planning. And as part of that process, we're revisiting different thresholds of capacity. So testamentary capacity is different. You might have somebody who's under guardianship who actually retains testamentary capacity. And has the ability to direct how they want their assets to go. And, you also might have somebody who doesn't, and then it's up to the guardian of the estate to put forward an estate plan that they think is in their best interests while taking into consideration what the guardian of the person thinks. We can deviate from the laws of intestacy. Those are the laws that create exactly how things should go by law in certain situations and circumstances, but court authorized estate planning is definitely its own presentation of itself. But, I just want to give you a little bit of a flavor of the different things that can happen within a guardianship, even after the adjudication event. So types of guardian, we pretty much have covered this already, but if anybody wants to jot down the statutory sections, please do. Plenary guardianship, that's your permanent guardian. That's for somebody who, as the CCP, the report of physician, it's also called the CCP 211. That's for somebody who totally lacks capacity. So a limited guardianship wouldn't be enough. Temporary guardianship, again, that's what you think of as your emergency. You need to go in right away. You find out about something on a Monday, you need to get into court on a Wednesday because that person's at substantial risk or has already been taken advantage of and you want to try to stop the bleeding. Your duty there is a showing of necessity for the immediate welfare and protection. And limited guardianship, again, lacks some but not all capacity and retains certain authorities. A standby guardian, a guardian can, once a guardian's been appointed by the court, they can designate who they would wish to act as a standby guardian. A petition has to be filed and the person who is adjudicated an individual with a disability should be consulted as part of that process to the extent that they can. So let's say in my situation I provided earlier where you have an adult, he just turned 18, he has autism, maybe mom is acting as guardian and mom wishes to appoint her other child to act in her stead if anything happens to her. Certainly you'd want to consult the ward to make sure that that appointment is somebody that he or she would be in favor of. He may come forward and say, well, no, I actually wanted it to be my brother. He also might not have a preference. And if that's the case, then you're specifying that in your petition to the court as well. Short-term guardian, just what you think it is. It's for any time that you think the guardian might not be able to act. So I had a situation several months ago where I had a guardian who was going into some pretty major surgery. And we wanted to make sure that, if the recovery process looked different than what we ultimately thought it was going to, that there would be a short-term guardian that could act in that person's place. And so in that case, we had the care manager who was assisting us, appointed to be able to assume those duties during that process. Okay, designation of a guardian itself. This happens before the adjudication process. Any of us that are sitting on the Zoom call who are competent, let's say we are executing our powers of attorney today, we are going to specify in our power of attorney who our preferred guardian would be. Very often it's the person you're specifying would act as your agent. If you became incapacitated, if that's how you structured your power of attorney document, and that's pretty good evidence for the court by the time that you get to the process of presenting, the choice guardian. A lot of times you'll see, that person comes to the court and the respondent is upset because they don't think that they need a guardianship put in place. The power of attorney is generally pretty good evidence for you to say, well, this is what the person wanted when they were of sound mind and were able to make a recommendation of what that would look like. It's pretty good evidence in that, although ultimately the court's responsible for determining who can best serve that person. Who can act? These are the statutory questions. It always feels a little bit strange when you're at a plenary appointment hearing because the individual has to be present. Of course, we're on Zoom right now. So those appointments used to be occurring in person, but now they're happening over Zoom. The judge will always ask these statutory questions, making sure that the nominated guardian's 18, resident of the US, has not been adjudicated a person with a disability themselves, and is not of unsound mind. So the judge will just ask the statutory questions to the guardian at that appointment hearing. And same goes for convicted of a felony. There are certain situations where the nominated guardian may have been convicted of a felony, but the court's willing to consider alternative evidence in support of their appointment. Maybe the family member is in agreement. Well, this happened, 15 plus years ago. None of us are objecting. Because remember, as part of that initial guardianship process, any interested person in the outcome of the appointment is getting notice. So that's kids, agents under power of attorney, adult siblings, parents, as the case may be. Everybody is entitled to come forward and say, hey, wait, I actually don't think that guardian's the right choice, or yeah, actually, I'm in agreement. A public agency can act, or a non-for-profit corporation capable of providing those services. So again, that's a care agency or a corporate fiduciary, which sometimes, again, people are resistant because they think, okay, but this agency is going to be charging per hour, or the corporate entity is going to be charging per hour, or taking a flat fee or on a percentage basis, or whatever their fee schedule looks like. Based on the assets that they're holding. But again, you weigh that with the cost of what the bond is for the guardian and the estate, if they're an individual. Plus, sometimes if you're in a situation where there's, again, over $500,000 in Cook County, the court's not going to give you much of a choice. They look at that and say, you maybe don't have, as a layperson, the ability to manage that much money. And the statute is pages and pages long. We can take a brief look at it of what the duties are for a guardian of the estate. But one of them is care and prudent management of the assets, investing, things like that. And, of course, we want to avoid lawsuits at the end of the day. So again, this is the corporation qualified and able to act. They sign an acceptance of office form, and that has to be presented at the same time of the adjudication hearing. All right. I think we've actually covered that one a little early. So quick kind of procedures of what we're doing before we get to the appointment. We've gone over the report of physician. We've talked about the guardian ad litem, the requirements of the petition itself. We've discussed you have to give people notice, and it has to be at least 14 days prior to the hearing so they have enough opportunity to be there and be heard. The standard is different for a temporary guardianship. You have to try to give reasonable notice. But again, it can't always happen because it's a true emergency, or maybe there's a reason you're not giving notice, in which case you tell the court, look, I'm not giving notice to the sister because she's actually, the exploiter. She's the one that we're concerned about. And the court says that's fine. The court has the ability to direct notice as it sees fit. Prior to us getting to that adjudication hearing, we're always going to have a guardian ad litem appointed. If the respondent is asking for counsel, appointment of counsel will happen at that point. And these are just a couple, if you want statutory references. We've gone through a lot of this, but sometimes people want to look through and write this down for a little bit more detail. What happens after guardian's appointed? We're in COVID era still. And so letters of office issue along with an order appointing the guardian. Those are two of what you would kind of think of as your guardian identification cards. for, let's just take the example of an individual, guardian of the estate, a family member, they would take those documents to a local financial institution and open up an estate account that will become really the basket account that holds the majority of that individual's assets. Sometimes there's a reason to keep assets at different financial institutions where a guardian of the estate is managing 2 separate accounts, or, you know, things like that. But generally speaking, we look to collect all the assets and hold them in one estate account. And then depending on how the assets are structured, obviously the investment schedule and plan is going to look a little bit different for everybody. So when we're not in COVID, we get the letters of office in person, they're stamped. They no longer have a raised seal, which sounds kind of silly to mention, but it's not, because the banks and institutions are used to seeing a raised seal. We're not doing that anymore. And so there's a separate document that's been issued by the court that can accompany the letters of office so that you guys don't have questions when the guardian's taking them to the bank. A notice of what's happened, it has to go out to the person who's been adjudicated a person with a disability. It notifies them of their right to seek termination of the guardianship or a modification of the guardianship. And, you know, that does happen. We do have individuals who, you know, might be under guardianship at one point, it no longer becomes appropriate, and they may petition the court for restoration. Here is what you are going to need to open a guardianship estate case with the probate division. These are, you know, staples. There's no way around it. The only thing you're adding to this is a petition for temporary guardianship, if that's how you're, if that's, you know, the approach that you need in your case because it's an emergency. Same thing. We talked about almost all these documents. Oath and bond of representative is just a fancy way of saying whether or not there needs to be a surety, a bond company. You need a surety if you're an individual and you're acting. You don't need a surety bond if you're a corporation that's acting. And you have to have proof of service. More often than not, I would say 99% of the time, we have an order entered that authorizes the use of a special process server. You know, we're dealing with individuals who are under some sort of disability, and the appearance of a sheriff with paperwork to serve them isn't really the most comfortable approach, right? And the court understands that and will authorize the use of somebody to serve them in plain clothes. That's how the person initially becomes aware of the guardianship proceeding. If you have somebody who totally lacks capacity, so let's say maybe they had a stroke and they're nonverbal, the sheriff is still required to serve them, but service looks different. The paperwork would be left at that person's side, you know, for them to theoretically be able to review. Same thing with the guardian ad litem. They're required to give that person their statement of rights, the petition, and other things but everybody's level of comprehension is very different. And a guardian ad litem report really will highlight exactly what the guardian ad litem's analysis is of the person's disability. So, you know, I think by way of quick example, I serve as a court-appointed guardian ad litem, and I had a visit last Friday. She's actually quite conversational. Initially, she responded that she was objecting to the guardianship. She felt very abandoned by her family. But, you know, once we talked about sort of what the guardianship was and the purpose of a guardian, she actually had, you know, changed her mind and determined that a guardian was really what she wanted at that time, because she didn't feel like she could manage her bank, didn't know where her assets were, and things of that nature. It's our job as guardian ad litem to advise the court if the person is objecting. It's not our job to convince them not to object. And so, you know, as part of that process, they have every right to information that you and I would have if we're going through this process, regardless of disability. Duties of the personal guardian. I'm going to pull up the statute here in a second, but the major one that everybody here has heard time and time again is the filing of an annual report. The court, doesn't go into the court. It goes into the court file, but not a matter of public record like the rest of the documents. And I guess I should mention too, that's, you know, when you're filling out the petition for guardianship, keep in mind that it's a public record. And so if that person, you know, has HIV or something along those lines, it's probably not a diagnosis that you really need to put on a public record. That's not the reason that they need guardianship, most likely. You know, I can't really think of a scenario where that would be relevant, right? And so let's just always think about how we're maximizing the privacy of that person in situations like that, while also giving the court the information that it needs. The annual report itself identifies these are, this is the person's need for guardianship and why. It's continuing on an annual basis. Here are the services that the person is receiving, which are very different depending on the disability that we're dealing with, the age, where the person is located. Are they in the community? Are they not? And that goes before the court. The court approves that on an annual basis. And I'll pull up the statute in just a second so we can go through some other pertinent points. Duties of the estate guardian always have to file what's called an inventory of assets and an annual budget. Those have to get filed within 60 days of the appointment of guardian unless the court excuses it. An inventory is everything that you know of that person owns. So their house, their bank accounts, their cars, their personal assets. Sometimes it's not possible to identify all of that in 60 days. Sometimes you might know of one bank account. You might file an interim inventory and come back to the court and update it. As time goes on, if they have an interest in a trust, anything that person has, the court is now responsible for the care and management of that person and overseeing the guardian of the estate in doing that. So I had a situation with an individual who had about 35 different accounts set up. That obviously took time to identify, because it's, as much as we would love for people to leave behind really concise lists of where everything is located, that's not always the case. A lot of times the guardian gets appointed and they have some pretty serious, obligations from that point of trying to figure out where are the assets located. We might be looking to the IRS for tax transcripts. We might be looking at their income tax returns, seeing what's generating income, trying to figure out where these assets are located, issuing subpoenas, whatever you have to do to make sure you have your arms around what they own. Because what you don't want is a bank account that's sitting out there that you haven't accounted for and, have that come back on the guardian of the estate. The annual budget is something that authorizes the spending of the person with the disabilities, the ward's assets during the time that there's a guardian acting. It's going to vary tremendously depending on the disability, the age, what you have as part of the estate, and that has to be approved by the court. So you may say, we've got $500,000 in this estate. We want to put mom in a facility that costs $10,000 a month. It's a private pay facility. And the court may say, no, I don't think that that's the most appropriate option. That's going to waste away the estate. It may approve it on a temporary basis, right? But you're constantly balancing the annual budget with the resources on hand versus if you have somebody where money isn't an issue, the court's going to look at this of a little bit differently of what can we continue to give them? Can we set up companion care? Can we, work in a vacation budget where they're able to take a vacation with a family member, that one family member is paid for as part of the process. But it looks different for everybody. Clothing's typically included, expenses are included. A lot of times to avoid having to come back to court constantly on petitions for authority to expend funds. Think of those kind of high things that you want to be able to do right away. So medical expenses, a lot of times I'll put upon receipt of what we call in this world a voucher, meaning I go to the hospital, we get a hospital bill, it's $15,000. The guardian of the estate doesn't think that there's an issue with how much it costs because they've insured that insurance supplies, things like that. If I can pay that out of the estate without having to go back to court, that's certainly, more favorable because any court appearance is going to cost the estate money. Things that you can't necessarily always account for, let's say, recently we have an individual who's about to turn 20. She has a pretty large estate, probably a little under $9 million. There's a vacation budget built in, but the family wants to do something a little bit more special for her 20th birthday. And so in that situation, we were required to present a petition for authority to expend funds. If it's an estate-owned residence, typically, let's say it needs a new roof or something like that, you're again going to be in there presenting petitions for authority to be able to expend funds for that purpose. If you need to switch placement, that's not something the guardian of the person can just do. They have to go into court and say, this is the level of care right now. It's no longer sufficient for X, Y, and Z reason. And this is the level of care, the increased level of care that's more appropriate. Hand in hand with that, oftentimes is the need to increase the budget because a lot of times they're moving from the community into a nursing facility. All of whatever is spent out of the estate then gets reflected in a current account. It gets filed annually. It ensures that you aren't, as guardian, or if you're the attorney representing the guardian in the estate, mismanaging any of the assets. Everything in that current account has to be pursuant to court order. And so again, if you're making large expenditures and it's not pursuant to that budget, that's where you want to make sure that either you're saying to the court, look, we spent $3,000, we didn't have an order for it, please ratify that decision for, X, Y, and Z reason, or making sure that you're going into court for every dollar that you're spending. Okay, give me 1 second while I screen share our statutory page. So this would take us forever and a day to go through the entire probate act. But, as far as definitions, and if you want just kind of refreshers on what an actual disability is and how it's defined, you're coming up to these early definition sections, and we went through this, early on in the beginning, but it tends to be a good guide. If you have a client coming in and you're having a difficult time convincing them or evaluating why guardianship is or isn't appropriate, sometimes it just helps to look at what the statute itself defines. So this is the long list of your duties as a personal guardian. So the person who's making those helpful decisions and things of that nature. Standards are, that they shall make provision for support, care, comfort, health, education, and maintenance, and professional services as appropriate. You're with the guardian and the person in estate are working hand in hand on that shared goal of making sure all the person's needs are met. There's a statutory section. I'm just kind of highlighting a couple things. Of course, we don't have the time to get into everything, but this is one that comes up more frequently than you would actually think. The guardian of the person has the ability to file for divorce or continue a divorce proceeding if one started. I do have plenty of situations where a divorce attorney calls me and they say, look, I'm concerned. I don't know if my client has capacity to continue on in this process. What will that mean? Obviously, if they started the divorce proceeding before being adjudicated a person with a disability, their intent of what they would like is pretty clear. And the guardian of the person under this part of the code can step in and kind of pick up from there. Let's see what other super important parts. I think this is one that it sounds obvious, but we always have to remember decisions may have to be in accordance with the following. Has to consider the current preferences of the ward to the extent the ward has the ability to participate in decision-making when they're known or reasonably ascertainable. So, it's hard because sometimes, like we said in that first example of son wants mom to go to a nursing facility, mom doesn't want to go to a nursing facility. We have to think about what that ward actually wants. We can't just say, I want to put her here because this is what I think is best for her. No, we really have to consider the dignity and care of that person when we're making decisions that are that important, the same way as we would want anybody to consider for us. We went through the process of an appointment of a standby guardian. This part comes up more frequently too than you would think. This is the visitation section. If a guardian unreasonably prevents visitation, this is the section that allows that person, that third party, to come to court and say, hey, I'm sister. My other sister is preventing me from seeing mom. There's no reason that she should be preventing me from doing that. The guardian, because the guardian does have the ability to control how visitation happens and in what mechanism to protect that person, especially if it's a situation of abuse or exploitation. But of course, that third party is going to have the ability to come to court and try to prove to the court visitation is being restricted. It's being restricted unnecessarily. But the standard is still pretty high for that purpose. So the court shall not allow visitation if it finds the ward has capacity to evaluate and communicate its decisions. So if mom's saying, nope, she's taken advantage of me my whole life, she stole $500,000 from me, maybe that's something even that's repeating for mom on a loop. She has the ability to express that to the court through her guardian, or individually, and the court takes that into consideration for sure. So, we have plenty of situations where, we would love to think that nobody takes advantage of anybody financially. Of course, that as part of what I do happens every single day, whether it's taking advantage of, a decedent's estate or a guardianship estate or somebody before they enter into guardianship. It's just unfortunately the reality of the world that we live in. So if mom's saying, I don't want to visit with that person, mom has the ability to do that. And the guardian, more than that, has the ability to restrict visitation to protect mom. Guardian of the estate statute, same thing. We're pretty long in this laundry list, but when you're signing up to become that guardian of the estate, you're becoming the fiduciary, you're becoming the person who's, same thing with the guardian of the person. You're becoming the trusted person to manage, those assets. This is the new section. It's not necessarily new, but section of our code that authorizes court authorized estate planning. These are the different kind of go-tos that you're looking at of what can a guardian of the estate do or not do. These come up when there's a guardian that's already appointed. Let's say there's a reason that the guardian of the estate needs to enter into a contract. Maybe there's maybe you have the ward owns a bunch of real estate. Maybe that person still has testamentary capacity. They tell you, I want to be able to maintain, this real estate empire that I've had my whole life. It means so much to me. And maybe they have the ability to do that because their estate is so great. So it has enough value to be able to hold real property of that nature. We can't just as guardian of the estate say, okay, we're going to go ahead. We're going to sign every contract that ever has anything to do with any decision regarding the real estate. No, we have the authority here to enter into contracts, but we have to go to court to do it. And so if it's starting to feel like guardianship is very court heavy, it's because it is. The court is really looking out for the best interest of that person and managing the decisions that are being made on a day-to-day basis. That again, there are plenty of decisions the person makes absent court approval, and there are certainly situations where a decision has to be made on an emergency basis and the court's consulted later. So think of my same scenario. You're managing a bunch of real estate. As part of that, you have an HVAC that goes out, and the tenant that is paying rent to you, that's paying rent to the estate, needs that done right away. You might say, yep, that's an emergency. I'm going to authorize an expenditure out of the estate for replacement of that. And I'm going to go to court later and seek the court's blessing of why that was immediate. Entering into contracts also applies for court authorized estate planning when you need to retain independent estate planning counsel to complete that goal of meeting with the ward and determining what it is they want. Also, applies, let's say you have a personal injury action that's pending, you need to retain an attorney for that purpose. Anyway, it can come up in a multitude of different ways, but the safe bet is always taking it to the court. Same thing goes if you need to sell a piece of real estate. Can't do that absent court approval. And there's kind of a two-step approach there that you have to be mindful of, and several different rules that apply to the sale of real estate in a probate proceeding that don't apply to the rest of us who aren't under guardianship, limitations on realtor fees, things like that. So, changing the ward's residence, that seems like something that might be the decision of the personal guardian. It is, but it also matters what the estate guardian thinks if they're two separate people. So let's say daughter is guardian of the person, bank is guardian of the estate. Daughter wants dad to go to a facility that's $15,000 a month. Dad's estate can't bear that expense. The corporation, the corporate entity, the guardian of the estates run a wasting projection. They determine that spending $15,000 a month would mean dad runs out of money in 3 years. The guardian of the estate has standing to object to a decision like that if it's not going to be in that person's financial best interest. Otherwise, I think those are just some of the ones that come up most frequently. On a contested note, and Bree, just start cutting me off when I've gone too long, because the process of guardianship is so extensive that I really could ramble on to you guys for absolutely forever about this, because I'm thankful to absolutely love what I do. But contested proceedings, how will you know it's contested? You file the petition for plenary guardianship, you notice everybody out, and in return, you receive a cross petition for guardianship. That will tell you right away, somebody doesn't agree with who you're recommending be nominated as guardian. Same thing, if the respondent is actually objecting, their counsel will stand in their shoes and argue, why they don't need a guardian. Sometimes people seem to get a little confused. I mean, attorneys are just going to do their job, right? So if you have respondents counsel and they're arguing vehemently that this person does not need a guardian, and you're sitting there on the other side of the fence representing the nominated guardian saying, but we're all looking at the same medical records, we're all seeing the same thing. Well, that's your job, right? To put forward the evidence of clear and convincing evidence why they should be adjudicated. It's the respondent's counsel to do their job and advocate for why the person doesn't have the need for a guardian. And at that point, that might be where the limited guardianship arrangement that we talked about comes into play, where you're able to come up with a settlement. Otherwise, you're headed to trial. Trial can look really different in guardianship proceedings, depending on what the issues are. If it's a capacity argument, you have different competing physicians that are testifying. You've got, if you're the guardian who put forward the petition to start, obviously as part of that petition, you had to have had a CCP 211, a report of physician that substantiated the need for guardianship. Without that, you can't file a petition for guardianship. You can't just say, I think this is the case. You really have to have, you need to have the report of physician in advance. And it's worth noting too, that report has to be within the last 3 months prior to the date of appointment. If it's not, you need to get a new one. But if it's a capacity argument, you've got the competing testimony of certain family members, the physicians, medical records. Obviously, we're then into the territory of evidence 101, making sure that you have appropriately authenticated your records, everything that you would think of in a standard trial. If it's a choice of guardian dispute, that's a lot different. Let's say everybody agrees mom needs a guardian, but sister wants to be it and brother wants to be it. Whoever you're representing in that case, you're putting forward all the reasons why your client is the best choice for guardian. Again, ideally, you're able to come up with some sort of settlement, just because, everybody's getting paid out of the estate. And so the court doesn't like to see, 3-4 different attorneys all, fighting and bickering, if there's reasonable ways to approach a settlement. So in a situation like that, can they act as co-guardians? Can they both make decisions for mom? If not, is somebody willing to enter into a settlement that says, I'm going to be the guardian, but brother, I am going to tell you every time, mom goes to the doctor, every time X, Y, and Z, I'm always going to maintain contact. If mom can't dial the phone herself, I'm going to be the one that's calling you, these several days a week at these times. Those definitely are settlements that we enter into, and it happens all along, because the biggest fear typically is, it kind of depends on if the person's coming from a good place or bad place, right? But is mom going to be taken care of? And of course, I'm just using mom. Obviously, if we have a younger adult with disability, the situation between parents can be very different, especially in situations of divorce. But the situation is usually, is mom going to be taken care of? We also have plenty of people who come to the table and say, well, am I going to be taken care of? I'm the heir, I'm the person, I'm the beneficiary, I'm all these things. How am I going to be protected in the end? And if I had a penny for how many times they've had to say to people, your inheritance doesn't come to fruition until the day that your parent passes, I think I'd be really rich. So, people, unfortunately, you can kind of see through that right away. And if you are representing the person who's only self-interested from a financial perspective, that's going to come out pretty quick. And so entering into some sort of settlement agreement might be in that person's best interest. Sometimes we'll agree to the estate plan cannot change. We're as part of this proceeding, no one's going to do court authorized estate planning. The guardian, it is what it is. Last estate plan is the one that controls. Plenty of different ways that you can explore settlement as part of a contested proceeding. But again, at the end of the day, you don't settle, you go to court, your issues are what they are, and the court ultimately is going to determine, after considering and weighing, and again, clear and convincing standard of appointment of a guardian, what's in that person's best interest. Before I completely leave you and start answering questions, let me see if I can share just a couple of those quick statutes that I promised you about different mental health issues. So I'm bringing up here the admin code. This is the protocol, and I'll pull up the exact site in just a second so you can write it down. But this section is protocol for securing informed consent for psychotropic medication. It specifies that except in the case of an emergency, no resident, so nobody residing in the facility, shall be administered psychotropic medication prior to, and this is very different than the standard for, somebody who's not residing in a nursing home facility, which I can appreciate sounds counterintuitive, but the standards are different for somebody who's sitting in an inpatient facility and not a resident of a nursing home, and somebody who is. prior to a discussion between the resident or their decision maker. So that's the guardian talking. So, that person is talking to the physician themselves, before having that conversation. So this came up really recently. We had an individual who was refusing his antidepressant medication. He's a resident of a nursing facility. It caused the facility great concern. And so they ultimately ended up sending him out to an inpatient care facility. And at that point, the care facility said, well, we're looking to the guardian for informed consent to be able to medicate this person. What is it that we can do? And this is the statute that you're looking at. You can't force medicate somebody, but if the physician determines, or if the nursing home determines that it's an emergency situation and, life, it's life or not, this person threatening X, Y, and Z, or they're suicidal because they haven't taken the medication, that's a situation where you're able to administer psychotropic medication, but it's very case-by-case basis. It's not a blanket. And so again, if a client's coming to you and saying, my son won't take his meds, I want to be able to do this, that's not what guardianship is for. Similarly, and I told you I'd give you that site. It's this part of the admin code 300-686. And this is about unnecessary psychotropic and antipsychotic medication. In the Nursing Home Care Act, there's this section 210 ILCS 45/2-1061. Drug treatment. Again, a resident shall not be given unnecessary drugs. It's a drug that's used in excessive dose or without monitoring, or a psychotropic. And again, we're very, very specific on psychotropic medications. Same thing, except in the case of an emergency, it can't be administered without informed consent of the resident or their decision maker. Psychotropic medication is defined here, thankfully, as is emergency. Emergency has the same meaning as all the other portions of the Nursing Home Care Act, but psychotropic medication is any mind-altering medication. So case by case, I would definitely encourage everybody to look at that before taking those next steps. As far as your situation with the end of the family who comes to you and says, my son won't take his medication, he's homeless, I can't get him, all these different things, you're into the territory of the mental health code. You are not in the Probate Act. I think that's best reserved really for another presentation, because that's just not the purpose of guardianship. So with that, I will stop talking everybody's ear off, and hopefully that was illuminating to some degree. And any questions, or actually it looks like there are some questions I can take a look through. All right.
Thank you so much, Missy. That was really great information. Really appreciate it. And yes, there is some questions down here. I see some Q&A. Do you prefer if I read those for you, or would you like to read those out loud?
I will just take a quick look through if that's okay.
That sounds great. Thank you so much. Really important information.
No, it's great. So one of the questions, this is an interesting one. Can I speak more to capacity, definitions of capacity versus DSM definitions? Definitely, legal. I don't know how the DSM defines capacity. I'm guessing that you're thinking more of, and re-raise this question, if I'm not kind of hitting what you're looking for, but decisional capacity from the medical standpoint is evaluated differently than capacity to make personal and financial decisions. And that's evaluated differently. We're thinking legal capacity versus medical decisional capacity. Sometimes they are symbiotic and sometimes they aren't. And so, for example, if somebody retains medical decisional capacity related to that example that I gave of they have end-stage cancer, they are saying, I don't want chemo anymore. The guardian's put in a really rough position because they're acting as the personal guardian for that person who lacks personal capacity. That's already been determined. The court's already made that decision. So at that stage, the guardian most likely would talk to the social worker and say, does this person have the ability to appreciate what that outcome would be? Which, let's just say the outcome is death. If the social worker says, I really don't know, I don't think they do. Best practice would be for the guardian to go to court and get clarification on the issue. The ward may attend. I've had a situation where that exact scenario didn't want the chemo, came to court, specifically specified they don't want the chemo, and had the ability to make that decision. So it's very case by case and issue by issue, which is never a satisfying answer. But if we applied the same approach to capacity, all things considered, we wouldn't really be looking at this from the more dignified approach. So Again, I think the most important one to think about for purposes of this presentation is that really low level of capacity, aka no capacity required to revoke the power of attorney for healthcare. I don't know that people really consider that all that frequently. And if we have somebody who's saying mom needs a guardian and mom's saying, I can't believe that my daughter's going to go to court and seek guardianship, they're going to revoke that power of attorney for healthcare. And then there's no decision maker in that in the interim. Let's see. Are there situations when guardianship is appropriate for someone with severe mental illness who's also homeless? This is always going to be the, this is the pit. And I'll say my best friend's a PA at Northwestern. I get questions from her all the time of, I have this person sitting here, they're specifying that they want to maintain homelessness, they don't want to be medicated. I do see medical records that evaluate that person's ability to make that decision that, I don't always necessarily agree with. Can that person actually appreciate what that means for them? Maybe, maybe not. So it's not that guardianship is never appropriate for someone with mental illness, but it's not appropriate if the only reason that a guardian would be appointed is to try to commit the person to an inpatient psych facility. That's just not something that's ever going to be. It's not that that person who would normally and always be entitled to a commitment hearing somehow isn't entitled to that anymore. They still retain the rights and ability to do that. So it could be, depending on the situation and kind of what the family is looking to do. If that same individual is somebody who would benefit from a nursing home, care facility, things like that, where the guardian does have the ability to direct placement, then yeah, guardianship would be an appropriate option. But if it's your 19-year-old who's choosing X, Y, and Z, and the thought is he really, really needs psych treatment, you're in the same situation as you often are, which it's frustrating. There's no way around it. I think all of us wish that there was, some way to advance mental health treatment for individuals who really need it. And sometimes we're able to work through that as part of the commitment hearing, and sometimes we're not. But guardianship isn't designed for that purpose. Difference between power of attorney and guardianship. You can't have both at the same time. And so they look the same as far as what someone can do and can't do. Although the power of attorney document itself is going to specify all the duties and ability of that principal. So let's say, taking into consideration the power of attorney for property. I've seen ones that authorize gifting. That's kind of unique. But let's say we have somebody who has a larger estate. They want to make sure annual gifting continues. That's something that would be directly specified. Otherwise, you have your statutory provisions present in every power of attorney that the person can either redact or add to, and those are going to control. And the power of attorney for property looks very similar, if not almost identical, but for the court involvement and extra layers of protection as a guardianship, guardian of the estate. Same thing goes for the power of attorney for healthcare. That's specifying, we have two different types. We have one that becomes effective immediately, and we have one that becomes effective upon the person's incapacity. It's up to the attorney to determine with their client which is appropriate and why. But, again, you can't have a power of attorney in place and the appointment of guardian. If you have the appointment of guardian, the power of attorney becomes, it's revoked, it's suspended. Let's see. Guardianship considerations for an adult child who's persistently abusing illegal substances harmful to health. Again, this is a really complicated part of guardianship, because if the ultimate goal is to be able to control where that person is going facility-wise, that's not what guardianship is for. Likewise, if the goal is to try to administer psychotropic medication, absent an involuntary commitment and that process of the hearing, guardianship isn't going to accomplish that. But let's say that that same individual isn't able to manage their resources appropriately. That could be a situation where a guardian of the estate is appointed to safeguard and manage those resources, while also acknowledging that there are going to be differences in how that person, how you approach that from a general health perspective. Let's see. How to discern between totally lacks capacity when mental illness allows the person to act one way or they seem in control. That's definitely a layperson's not going to be able to do that. I may look at somebody, and I actually have a situation right now with an adult who's an alleged disabled individual who has a plethora of drug addiction issues that impact that person's ability to make personal and financial decisions. They also have dual diagnoses that related to certain overdose events. They've had an anoxic brain injury, so that's impacting their ability on a more long-term basis for long-term processing and reasoning. That's where the report a physician comes in handy, because that's a professional who can actually step in and evaluate what that person's capacity is, not just on a snapshot view, but on a long-term basis. And that's where totally lacks capacity and partially lacks capacity are very different. We typically use geriatric psychiatrists as part of what I do. There are other psychiatrists certainly that are involved that can do these more thorough evaluations, but if the person's primary care physician is not willing to fill out a report of physician, there are alternative options. But that tends to be, your best approach, or the psychiatrist, can come to you. Let's say you're a parent and you're parenting somebody who has severe mental health issues, and maybe it's paired with drug addiction issues. The first step ideally is going to the psychiatrist and saying, look, I don't know that my son or daughter can make these decisions on his own, and I need you to help me in understanding that process. If, the physician comes back and says, this person can, they are completely able to make personal and financial decisions, guardianship isn't going to be the right approach. But, certainly better left to the professionals on that one. Let's see. Guardianship considerations for an adult child who's persistently unable to comply with restraining orders due to mental illness. It depends. We have we had a situation with one adult with a disability who, because of his disability, really wasn't able to appreciate the outcome of certain events. So was sending explicit photos to people on the internet. And in that situation, the guardianship process allowed us to sort of control his access to social media. Again, the court is going to weigh that person's First Amendment right against the restriction, but in that situation, because it was impacting other people, the court determined that that restriction was most appropriate and the least restrictive alternative to protect that person from making decisions that were going to be harmful. Let me see if anything else has come through. If anybody has, okay, how does somebody reach me if they have a guardianship issue that requires attorney involvement, or at least, you want to pick my brain? I'll put up my contact information quickly, and you can just take down my email. Again, if it's email and phone number, if it's a situation where you're just not sure if guardianship is appropriate, you can always reach out. And I'm happy to tell you, yep, that's what guardianship can accomplish, or no, it can't, because certainly we don't want to set unreasonable expectations of what the court can and can't do. Let's see, there's another question about, capacity as related to personality disorder. We definitely have, and you might remember from our definition of disability section. Let me find that quickly. That a person with a disability can be defined as a person with mental illness or a person with developmental disability that, because of mental illness, is not able to fully manage person or estate. That certainly happens. And so, again, it just depends on what the physician would recommend and whether the physician is stating with certainty that the person can or cannot make personal and financial decisions. The best alternative in situations where, let's say, the physician says this person's fully competent, I have no concerns, maybe that person is willing and able to sign a power of attorney, and it becomes effective upon that person's incapacity, and maybe that incapacity is more temporary in nature because of the use of illicit substances. The power of attorney then at least allows that person to step in and make decisions for the agent during times of temporary incapacity. And there's also a mental health form that individuals can sign. It depends on who they are, but I'm happy to talk about this in a different presentation, or if anybody needs this resource or call. We as estate planning attorneys can draft and do draft documents that specify, I am signing off that I am going to allow my husband to make X, Y, and Z decisions for me from a mental health perspective. I'm doing that with full knowing capacity. That document certainly a valid operating document that becomes really useful. The reason that we don't see it happen the majority of the time is because people just won't sign it. But a mental health declaration document could be really useful for a situation like that. Can a person with limited capacity because of assault be sentenced to mental health prison? I'm not sure exactly. That question would need a little bit more clarification for me to be able to weigh in. How to get a doctor's report on an adult child not willing to share the report. The physician should be willing to share the report of physician with you directly. If you're obtaining it for the purposes of knowing whether the person needs guardianship, that report of physician is not necessarily considered a private document. We have a couple more, but then I'm gonna try to wrap up here. There's a situation with an individual who has a son with developmental disability. He's going to be turning 18 soon, so he'll be at the age majority. The family is trying to decide between a power of attorney for healthcare and property and guardianship. The worry is that the POA can't he revoke at any time? Yep, that's true. Level of capacity is different for a power of attorney for healthcare than it is for property, but they are low levels of capacity. Power of attorney of healthcare, if he needed, for example, life-saving surgery, yep, that would work. If he's scared of the surgery and he says no, he doesn't want it because he doesn't understand, there would be nothing that they can do in that situation, but with guardianship you can, right? Yeah. So guardians can consent to surgery, especially if it's something that person needs. The thought being that, and powers of attorney can consent in certain situations too, but you do have the added layer of the court. And so, if you're in doubt and there needs to be a life-saving treatment of some kind, you can always go to the court for an additional layer of protection and guidance. But that tends to be wherever a power of attorney can operate and is effective, we love using them. So for me, in my situation, a power of attorney is great. If I walk across the street tomorrow and I get hit by a car, my husband can make all of my health decisions for me under that document. At the same time, let's say I now have an additional level of mental health illness that's paired in here where I'm a little bit more unreliable. I might get hit by a car and I might then say, actually, I don't want my husband to be able to do this anymore. Guardianship becomes your next and only alternative to make sure that person's protected. Okay, last question that I'll be able to get to is, what is the best way to safeguard an inherited estate for a person with serious mental illness, a manager of the trust, or a guardianship of the estate? Your first bet is always going to be creating a special needs trust in that initial document. If there is not an SNT created, so let's say my grandma leaves money to me and she left it to me outright, it's possible to go through the process of something called decanting, where we change the terms of the trust to decant what I would have gotten otherwise into a special needs trust to protect me from myself. If the trust has already started to be administered, that's not going to be an option. But yes, a guardian of the estate would be able to protect those inherited proceeds. And certainly, when you say manager of a trust, it just depends. It depends on how the operating trust is actually structured. So if you think of, your more traditional trust and it stays in trust for my benefit, I'm the one who has serious mental health illness, that trustee is going to be able to protect those assets under the terms of the trust itself. Now, let's say I also receive benefits. We're going to want to make sure that trust, those assets held in trust, that there's very specific and detailed language in there, making that a special needs trust. It's considered a supplemental trust, right? It can't replace your government benefits, but it's there to supplant your benefits. That's a process that certainly I'm familiar with. I'm happy to walk you through if you need more information on that. But ways to do it. But unfortunately, I think what we all have to remember is if we have a child who has disabilities of any kind and we have any amount of wealth and we intend to pass money at all to our kids, making sure we're working with an attorney who has that extra layer of knowledge in special needs planning, so that we're not falling into a situation where I die and my money comes into the hand of somebody who can't manage it. So all really great questions. I appreciate all of them so much.
Thank you so much, Missy. Such great information, and like you said, really great questions. So it seems like our audience really appreciated the information that you were willing to share. And it was such a beautiful day out today. So I really just thank you for taking time out of your day to meet with us and share your background and everything that you have to offer for our communities. We greatly appreciate
Thanks
you.
for having me. No, thanks.
Yeah,
so much.
it's been great. Yeah, of course. All right, everybody. Well, we're starting to wrap up now. And so I'm just going to leave you with a couple last minute things. If you enjoyed tonight's presentation, you can find more information about some of our upcoming programs and events at www.namiccns.org. Our next program will be held on May 24th. So mark your calendars, please, from 7 o'clock to 8:30. Beth Neighbors, who is the executive director at Journeys, will present on all things housing. We are also gathering together for our annual gala. It is coming up very, very soon on April 29th. So if you are interested in purchasing a ticket, coming to our event, please visit our events tab on our website. That is where you can purchase a ticket. Lastly, once you log off, you will see a short survey that will both allow us to better understand your comfort level with today's presentation and topic, as well as assist us with future webinar topics. This data that we collect is really important for us. It helps us write grants and obtain some money so that we can continue to provide these free services to our communities. And that's a wrap. We appreciate your presence tonight, and we look forward to seeing you again at a NAMI CCNS community webinar. Please take care of yourselves and take care of each other. Bye, everybody. Have a good night.
Am I all right to log off? Thanks.
Thank you so much, Missy.
You're so welcome.
I appreciate it.